Good morning and welcome to today's Ask a Pro webinar. Today's topic is consumer collection, topics and trends for 2023. My name is David Head and I will be the moderator for today's session. I'm the Consumer Collections Group Chair and a shareholder here at Weltman. I work out of the firm's Cleveland office and I've been with the firm for over 20 years. For that entire time, I've practiced in the consumer collections space. After spending time as the lead attorney in Ohio, I was named the Consumer Practice Chair 2 years ago. In my role, I'm responsible for all things consumer at the firm. This includes collections and litigation, attorneys and staff, as well as our policies and procedure. But I can't do this alone. I have a number of great people that assist me, and a few of those are on the panel today. So let's meet the panelists. How about we start off with Dan?
Thank you. Good morning. My name's Dan Best. I am the partner in charge of legal collections for the state of Michigan. I am licensed in both Michigan and Ohio, as well as several tribal courts, and handle any of your legal collection matters for the entire state.
Thank you, Dan. Good morning, Mike. Go ahead and introduce yourself.
All right, good morning. My name is Mike Dougherty. As you can see, I'm the best dressed person on the panel today, so I would like to point that out. I'm out here in the Philadelphia office. The Philadelphia office, in conjunction with our Pittsburgh office, we cover all of Pennsylvania. We handle your collections, replevins, bankruptcies, foreclosures. In addition, out of Pennsylvania, out of the Philadelphia office, we also cover the entire state of New Jersey. We look forward to talking to you guys today. Thank you.
And Jamie, last with you.
Hi, everybody. Jamie Hart. I'm an attorney, shareholder in our Cincinnati office. I manage our Kentucky, Indiana, and Southwest Ohio litigation practice. Been with the firm since 2009, and my personal primary practice is mainly in Kentucky and handle all your needs there. And the only reason I can say that Mike's best dressed is because today is opening day, so happy opening day to all who celebrate, and we all know that Philly doesn't really have a baseball team to celebrate, so look forward to talking to everybody today.
Coming from Cincinnati, that took a lot of courage, so give Jamie props.
Agree with all sentiments there. All right, well, let me go through a few things. Before we get started, I'd like to take a moment to go over a few housekeeping items. As a reminder, this is an interactive session, so please submit your questions through the question button in the control panel. Those questions will be addressed during the presentation where applicable. This webinar is being recorded, and at the conclusion of today's session, a link to the recording and a copy of the presentation slides will be sent to all the attendees. Also, there will be a short survey on your screen at the conclusion of the event. Please take the survey and share your feedback, because we greatly appreciate hearing your opinions on our webinars. Lastly, our legal notice. This seminar presentation will provide information concerning potential legal issues, concepts, factual situations, and information. This seminar and the material provided are not a substitute for legal advice from qualified counsel on any matter, including similar or exact factual scenarios that may be provided or proposed. This presentation is not created or designed to address the unique facts or circumstances that may arise in any specific instance that you should not and are not authorized to rely on this content as a source of legal advice. The presenters advise you to seek competent legal advice on these topics. This seminar or seminar materials do not create any attorney-client relationship between you or the law firm of Weltman Grace. Sorry I had to say that, but that's a very long and long-winded way of saying that. Without further ado, let's get to the first topic. Over the last couple of years, there's been no greater hot button issue in the collections industry, especially on the consumer side, than the debt collection rule. In October of 2020, as well as December, the CFPB released Regulation F with an effective date of November 30th of 2021. So everyone had about a year to update their compliance management systems, update their policies and procedures, identify relevant data, and test all of this. Regulation F mainly restated the FDCPA with some clarification, provided very safe harbors, and addressed new technologies, with a focus on communication, the debt validation notice, and time-barred debt. Now that more than 1 year has elapsed, we are asked the very same question that we were asked leading up to November 2021 in the Regulation F rollout, and that is Regulation F applicable to an original creditor? Who wants to take that one?
I'm happy to take it. So as David just sort of gave a brief background of Regulation F, it's been in our lives now since 2020, but really effectively since 2021. And the short answer to the question is no. Regulation F, also known as the debt collection rules as issued, apply to debt collectors. And as a first party creditor who's collecting their own debts, those rules don't apply. The rules we talk about, I think, have become kind of, in the nomenclature now and sort of in our lives, such rules as the 7 and 7 rule, the MVN, model validation notices, limited content messages, things like that. Those really apply to debt collectors who are collecting on debt. With that said, however, they do affect clearly first-party creditors because you have to work with agencies, attorneys, things like that to collect your debts. And so that, number one, the way it affects you is in oversight. The CFPB has supervisory authority over certain entities based upon certain thresholds of, for example, Weltman, Weinberg, and Reese. We are subject directly to CFPB oversight. As a result, if we are your attorneys, we're doing your work, you have vendor oversight responsibilities. You got to make sure we're doing the right thing. So even though you, as a first party creditor, you may not be subject to the 7 and 7 rule on contacts, you got to make sure that we are. And so that does, you need to be aware of those rules and make sure that you're handling, handling those affairs and doing those audits. The other real impact to a first party creditor is with the information that is now required to be provided, especially at the referral stage. Prior to the debt collection rules, the demand letters, what we would call them, would be sent out. Those demand letters were provided by the FDCPA. And as David had said, the debt collection rules, again, Reg F, really restate in a lot of ways the FDCPA, but then also provide some updates, some safe harbors, and really kind of try to tackle some of the new technology that wasn't out in the 1970s when the FDCPA was issued. And part of that, too, is a renewed demand letter, which we now call the model validation notice. And the amount of information that you have to provide as a first-party creditor to your agency, to your attorney partners to issue those is very significant compared to what it used to be. And I think if anybody's had to fill out and complete a Regulation F's referral sheet, whether from us or someone else, you've already seen how dramatically different that process is now.
Thanks, Jamie. So in addition to that, we've got obviously whether or not it impacts the original creditor. We do definitely know it impacts institutions like we are, a third-party debt collector. Those impacts reach beyond just the third parties. And so we're going to go on to the next question and maybe dig a little bit deeper into how those impacts reach you as well. So question number 2 was, what impact has Regulation F had on collections, including collection lawsuits?
What I would say to that, and anybody else can chime in, I see a couple of impacts. Number one, and again, we've been living with this now for a little over a year. I think one of the first things I see is there's been a diminished amount of lawsuits and lawsuit activity based upon the fact, again, the amount of information that creditors have to provide at the initial stages of the referral process has kind of created a delay in that. I don't think that's going to, in my opinion, going to sustain over some time, because I think as we get more familiar with the rules and the way in which and the information that we have to provide, I think that will subside. Also, in a positive way, with having to provide that information, let's be honest, with having to provide all this information at the outset, it makes things sometimes a little bit easier as we go through the collection process, because we've got this information at the beginning. We're not having to go back and figure it out. We're seeing more detailed accounting, more detailed documentation, because again, that is all now required. So from a positive standpoint, it's nice to have that information at the ready as you go through the collection process. But again, I do think it is impacting the quote number of collection lawsuits, but in a lot of ways, it's allowing these lawsuits to proceed through the process with a little more confidence that we've got everything at the ready. The only other thing I would say that is impacting is, again, going back to the MVN and the amount of information that's being provided, the need to provide detailed accounting for everything that you may seek as a creditor, regardless of whether it's allowed by state law or not. If you're seeking information such as collection costs, repo costs, whatever the case may be, you have to specifically detail that in greater detail and provide documentation to substantiate that at the outset. What I see is with some of our clients is that we may be foregoing those at this stage in order to just move forward with, again, what may be maybe an easier linear amount to prove when you get into a court of law and have to produce your evidence of that.
And I think I would agree with a lot of what Jamie said there. And the one thing I would point out as well, a lot of familiar folks on this webinar, and I think the one challenge that everyone has said, it's on the front end, right? It's the ability to get that information that's now required for that MVN through Reg F. And it's new to your systems. So it's a matter of just kind of adjusting, getting that information over in an effective way, because that's kind of where the delay has been initially. But what we've seen is everyone's adapted. We've learned the new rules. The folks on the webinar have learned the new rules, and I think everyone is kind of getting to a better spot of getting their systems able to just more precisely and cleanly get those data points over. And then once those data points are here, just like Jamie said, it does make the suit actually move a little bit smoother, because now we have the information up front, which maybe in the past we'd have to reach out in the back for. So there are some positives, but it's getting through that front end that I think is really the big challenge.
And I think the other thing we had expected to see was an increase in disputes, because the MVN provides a much easier way to dispute the indebtedness. That has not occurred to any degree that we had first expected. And I concur as to the collection lawsuits, there's a delay, but I think by adding the additional documents, we actually see less frivolous answers. The person is sort of having to respond. They're not filing the answers as a result. Actually have seen the number of defaults increase slightly. So I think there has been a positive effect on our ability to collect.
And I would just add, before we move on, there was a great question that was asked about what does the lending process have to do with Reg F, or how does that affect? And I think it's a great question, because we don't really think about the lending process when it pertains to Regulation F, because we're talking about debt collection, right? So when you talk about the front end versus the recovery side, what I would say is the lending process can help in the Reg F and compliance part, because a lot of what Reg F requires is consent. When we talk about communications, things like that, making sure you have informed consent to communicate with all these different technological advances we have, like cell phones, text messages, social media, things like that. So on the lending side, making sure that when you are lending to your borrowers, to your members, that you are capturing that information, not only accurate information, contact information, but also capturing that consent. And that will help tremendously on the back end later when you're, when unfortunately things go south.
So I want to bring up a question while we're on this Reg F. We've just got a question from the audience. As far as non-consumer cases, a person here says, we have had 1 or 2 outside counsels send the regulation notice. Do you suggest doing this for those types of matters? So non-consumer matters, commercial, let's say commercial matters. Do you suggest following Regulation F and sending those notices in that situation?
I would say it's really up to you how you'd want to do it, but you are not required. Regulation F is very clear that it applies to consumer debts, not commercial debts. So I will tell you that in my practice, on my commercial practice, I do not. It is not required, and so you do not have to do that.
Now, we do some commercial credit card collection work, and in those cases, it's an individual who's on the hook along with the company, and you see what clearly are non-commercial activity on the accounts. So in those cases, we do send the MVN. So I would suggest that you review the type of credit that you are pursuing, and if it's possible that the credit was used in a consumer type manner, that you would send the MVN.
All right, very good. Although we'll touch base on some other Reg F things probably throughout the presentation here today, I'm gonna step away from this for a little bit and look at maybe some other trends that we're seeing. So moving on to question 3. We've had a question that I've asked, have you seen any trends in state courts requiring additional documentation to support suits and obtain judgments? We touched a little bit on obviously some additional documentation through Reg F, but what about from the court side? Are you seeing that coming through in any of the states that you practice in?
If I may.
Beyond,
Yeah, Dan. Oh, yeah.
I'll go ahead. Beyond what's required by Regulation F, we really have not seen anything on the suit side in Michigan. Now, the obtaining judgment, there was recently a change to Michigan court rules. As a result, historically, we could file one document that was both a default and a default judgment. Now we have to file a default, wait, serve the debtor, or serve the defendant, excuse me, and then file the default judgment. So we have seen a slight increase in our timelines towards obtaining judgments in the state of Michigan.
Mike?
And I would say for Pennsylvania, Pennsylvania is a county-specific state, so each county has their own rules. But what we're starting to see is, I'll call it a disturbing trend of some of these counties establishing their own rules for purposes of how to file a suit and the documentation needed. So traditionally, you would file a lawsuit, you would attach the contract, and you would attach a statement, and that would establish your case to begin with. So what you're seeing courts now do is they're almost making you prove your case at the time you file your complaint. So they're requiring us to not only have that contract, but also have a significant amount of statements attached at the time of filing the complaint. So when we talk about additional document requirements, that's something that's going to filter out to you guys on the webinar right now, because we're going to be asking you for those additional documents, not because we necessarily want to burden you, but the courts are now, at least in Pennsylvania, starting to trend in that way. So our hope is it gets limited to these few counties and it doesn't spread further, but we're keeping a close eye on that. And on the New Jersey side, the good news is business as usual. It's a uniform state. It's pretty much not required any additional documentation on the complaint or judgment side. So we're keeping our fingers crossed in Jersey that we do not see the same trend that is starting to appear in PA.
For Kentucky, and I can speak to Indiana as well, I'd say there's nothing, there's no seismic shift that's occurring in any kind of way. It really is county to county, judge to judge as to what certain courts require to obtain judgment. It's very uniform as far as filing a complaint, but getting judgment, it really runs the gamut. Some courts do not require much. Some courts require, your firstborn and a DNA sample. So you got to provide a lot of, when you hear from us, a lot of it has to do with the fact that, yes, we are in a court where we're going to have to provide a lot of documents. And for both states, I'll tell you that if there is any trend, it is certainly a trending in the way of more courts wanting more documents. Not necessarily more documents necessarily, but more courts expanding the view that they're going to want more documents. And that's not necessarily in the contested cases. That's more or less in uncontested cases. So yes, documentation is certainly key. And if there's any trend, it's going that way.
And I would speak up for Ohio. I would say it's not a new trend. Ohio, maybe like some others, we've had courts and judges historically who have required that. As those courts and judges change or cycle out to new judges, that trend may be to require less or more. So we sort of adapt as we learn these things, and especially with in our state with elections, that could bring changes. And we maintain a court matrix, right? We keep track of that because it's very daunting to try to have that all in our head. So it's, putting it on a matrix and referencing that so that we know what is necessary in individual jurisdictions is critical. So that's how I would say we address that in Ohio as well. I know we've got a couple of questions coming in. I'm taking those down for hopefully we've got some time toward the end to address some of these, and we'll get back to them as many as we can. But we do have some other questions here that we want to get to. So the next one I'm going to go to is 3 years ago this month, the entire country went into a lockdown, right? So lockdowns varied from state to state. We practice in 7 specifically, and they range from the extreme to maybe not as extreme. But the way that we litigated cases was universally impacted. Most specifically, litigation ceased for at least some amount of time due to court shutdowns or creditor moratoriums. As the courts have reopened and the creditors have authorized litigation again, we're doing so remotely. So question number 4 is, are the courts maintaining COVID era remote hearings, or have they returned to in-person hearings? And how is that impacting the creditors? So let's start with Mike on this one.
Sure. So what you're seeing for PA and New Jersey is Pennsylvania in particular, they went back to business as usual pretty quickly to in-person. Jersey's held up pretty well as far as keeping those remote hearings. At the end of the day, what does that mean to you guys, right? That's the only thing that matters as far as that context. We still have to get to the courts on your behalf, and we're going to be there. But where it's good for you, especially in New Jersey, the more they keep with the Zoom hearings, it just makes your life easier. It makes our lives easier. So in New Jersey, we're seeing those Zoom hearings. The downside we're seeing is a lot of the courts now aren't granting some summary judgment motions, which is forcing more hearings. So what you're seeing is we're making more requests in PA and New Jersey for you folks to come out and attend hearings, whether Zoom or in person. But fortunately, in New Jersey, it's trending in a good direction to save you some travel time. In Pennsylvania, unfortunately, it's back to in person and doing some travel.
Jamie?
For Kentucky and Indiana, it's definitely trending back to in-person. I would say specifically for Kentucky, more rural areas are definitely back in person and have been for some time, whereas some of the more urban areas like in Louisville, Lexington, you are still have a pretty good option of attending remotely, but not necessarily for trials. And as Mike said, for the folks here on the webinar, that means if you're having to attend as a witness, that is generally speaking always going to be in person from going forward. And for Indiana, for example, Indiana really has always been very remote friendly with telephone calls, call-ins, Zoom, things like that. But I know that just as we just got notice here in the last week or so that Marion County, which is Indianapolis, is going back to all in-person hearings starting August 1st of this year. So again, they're still out there, but the trend is definitely going back to business as usual pre-COVID.
Thanks, Jamie. How about Dan? How about Michigan?
Well, Michigan, fortunately, Michigan's a unified state, a unified court system, and the Supreme Court has directed on civil actions for the hearings to be conducted by Zoom unless there's a reason not to. And as a result, although we've seen an increase in in-person hearings, it's not to the degree of what I hear from the other states. I expect that we will maintain that. There's been no indication that the Supreme Court's gonna overturn that or reverse that decision. I think the courts have become acclimated to handling cases by Zoom. I think one of the odd things is the percentage of defendants and pro per defendants appearing by Zoom has skyrocketed. I mean, I literally 75% of the times, if I'd go to an in-person hearing with a pro se defendant, I would walk out with a default judgment. With Zoom, they're showing up 95% of the time, which is a very good thing because I get to interact with them. We get to work out payment arrangements. So it results in additional funds or funds coming to us quicker than they would if I took a default judgment and tracked them down and served a wage guard or something like that. As far as impacting creditors, one's an example this week. I have an in-person hearing that just got set up for an evidentiary hearing. My client's in Ohio. We requested the court to allow the client to appear by Zoom. This is a court that would never have allowed pre-COVID telephonic or any other appearances other than in person, and they've granted the request. So I do see it as greatly improving the efficiencies of both us, the attorneys, you, the creditors, as well as the courts themselves.
In Ohio, we are the exact opposite of what Michigan, as far as being unified. Every court pretty much determines what they want to do on their own. And so we do, again, need basically a matrix to keep track of all of this. But what I will tell you is, there are a number of courts that have definitely moved back to in-person. But what they've done, though, is maybe the trials or the ending of the case is more in person. They have done a great job at realizing that they can manage a docket much more efficiently by not requiring, all of the parties to be there or the attorneys even to be there. So courts that had historically not been willing to do anything remote or telephonically, or at least doing that for case managements and scheduling purposes, as opposed to showing up, being there for a minute or two, and then walking out. So that has been a bonus that we've been able to get through, and hopefully we'll continue to see courts maintain that, at least again for those case management and scheduling matters. So, but another trend that I wanted to touch base on, because we definitely have seen this, is last year, seemingly out of nowhere for many of us, a state in Arizona, state politicians passed a law that greatly limited post-judgment executions by increasing or adding exemptions. So we've had the following question: are you seeing a trend in state legislatures and or courts proposing or adopting new legislation and court rules impacting collection litigation? Move to the next question on the slideshow, please. Never mind. So maybe that's not, there it is. Okay, thanks. So I'm going to drop this to Dan initially. He had mentioned earlier that on some, he had already, I guess, given us a little bit of a preview that there are some recent changes in documentation requirements. But I know there in Michigan there is some activity occurring in the legislative side of things too.
Yeah, both legislative as well as with the courts. So several years ago, the Supreme Court commissioned a Justice for All Commission. Last year, that commission came out with their recommendations on debt collection lawsuits. And, unfortunately, when you read it, they had a number of recommendations, and it looks like they picked the facts to make the story to get to the recommendations that they wanted to make instead of letting the facts write the story. We, as a Creditors Bar Association here in Michigan, went through them, and about half of them seem to make sense. Several can be done by the Supreme Court. Most has to be done by the legislature, which is why the Supreme Court would have had recommendations done that would be for the legislature and not for the courts is an interesting question that nobody seems to want to ask. But that being said, we are seeing nothing introduced as of yet, but a lot of legislation like what was introduced and passed in Arizona. This is being financed by the Pew Charitable Trust, which is a very left-leaning organization. We believe that's the same organization that was behind the Arizona changes. The Michigan Creditors Bar Association has instituted an additional PAC contribution from its members to ensure that we are in a position to battle against these, so that we have our say in any legislation that does get passed. I would strongly recommend that you have your PACs, especially those of you in Michigan, but for all states, be bolstered and be aware that this is a nationwide phenomena. It's not limited to any individual state. I know, for example, in Illinois, they're actually looking at creating a state-level CFPB. And so, that's another thing that I'm sure if it passes in Illinois, other states will start looking to pass it. So you need to be aware, and you need to be supporting your PACs so we can battle against this initiative.
And I'll just chime in on a couple other points in Illinois, or at least one other that I want to get to, because we're going to talk about it here in a little bit. One of the proposals pending in front of legislation is the elimination of judgment revival for consumer judgment. So specific as to our industry, judgments typically have some sort of a lifespan to them, sometimes in forever. But specifically in Illinois, one of the proposals is to eliminate the ability to revive judgment. So I think very simply, is this a trend? Are we going to see this? I think yes. Mike, Jamie, and in any of the states that you're practicing in, there anything currently pending, or is it all quiet so far?
I'll speak to PA and Jersey. PA, Jersey, pretty quiet. Jersey, especially quiet. PA, you're seeing some local courts add some additional stops along the way in order to get your judgment, making you show up at different types of conferences, which never happened before. And they're focused solely on the collection industry. So these same conferences are not geared to a medical malpractice case, a products liability case. It's solely within our industry. So you're starting to see that. And then kind of the 1,000-pound gorilla in the room when we talk about new rules and trends. It's nothing legislative, locally or state or court rules. It's the old CFPB floating out there, right? So at any moment, who knows what they can do to change all the rules of the game. So otherwise, so far so good in PA and Jersey.
I would say the same in Kentucky and Indiana. Nothing on the immediate forefront that I don't think, especially nothing like what's going on in Michigan or what's being proposed in Illinois. But to Mike's point, there's a session every year, and there are things that propose. Right now, there is a House bill in Kentucky that essentially seeks to undercut judgment lien enforceability after 10 years, which typically they're enforceable for as long as the judgment's enforceable. So nothing, again, earth-shattering at this point, but yes, you have to keep your eye on it.
All right, great, thank you. I'm going to move it to the next question here, because this is if I'm ever anywhere in our industry and I'm asked one question that comes up the most, it's surrounding statute of limitations, and basically, why is it so difficult to determine the statute of limitations of any of the obligations we're going to pursue? And are you seeing any trends involving statute of limitations? But let's start with the why first. Who wants to jump on that one?
I will do so, because Michigan's one of those states that's very difficult. So you go into a dealership, you buy a car, the dealership assigns it to the finance company. That actually has a different statute of limitations than if I went into the finance company itself, signed a note, took the proceeds, and bought the car. In the first instance, you're dealing with a retail installment sales contract, and it's a 4-year statute of limitations in Michigan. In the second situation, you're dealing with a contract and note directly with the financial institution. It's a 6-year statute of limitations. So at least in Michigan, you've got, whether it's indirect or direct, affects the statute of limitations. The other thing that is difficult is it generally goes from the last payment, but at least in Michigan, this is the last voluntary payment. So if you get a CPI insurance refund, that's not a voluntary payment. If you see sale proceeds from a sale of your collateral, again, not voluntary. It's got to be from your debtor and voluntarily paid, so he's acknowledging the debt. So that's a couple reasons why, at least in Michigan, the statute of limitations can be difficult to determine.
Jamie?
Yeah, and I would echo what David said. I mean, this is probably the hottest topic you get as a collection lawyer. This is like our free bird. You know, everybody wants to know and everybody wants to hear it. What I would say for Kentucky is very similar to what Dan was talking about with Michigan. It is not as simple, and it's much more complex than I feel like it used to be. There are a lot of different factors that go into it. Like Dan, I mean, we've got 4-year statute for retail installments, 6 years for leases, 10 years or 14 years for written contracts, depending on when you signed it. Then you also have a 6-year statute for negotiable instruments. And what is a negotiable instrument? Well, if you go to our website, you'll see a great article I wrote a few years ago that explains it. It's very lengthy, so I will not do it all here. Also, Kentucky has a borrowing statute, which makes things even more complicated because while we love our state, we love our statute of limitations, we'll borrow someone else's if certain factors are present. And what I would say is these are what used to be, I think, a pretty straightforward answer sometimes is not. So I encourage everybody on this webinar who's watching this, if you have questions, reach out to your attorneys. It's so important to get this right the first time as you go through, because again, going back and circling back to Regulation F, there's a lot of there's a lot of discussion, a lot of rules now regarding time bar debt, and essentially it's pretty clear. You can't sue on it, you can't collect it. So you want to make sure that you know the statute of limitations based upon the product or instrument you have, and that you're getting that into the legal process if that's what you choose to do in a very timely manner.
Mike, how about Pennsylvania, New Jersey? Simple?
Yeah, I would echo what everyone said here. It's relatively simple to a degree in the sense that PA, you got a 4-year contract statute, which applies to just about every type of contract. So pretty clean there. Jersey, similar to what Dan is talking about in Michigan. If you're talking about the sale of goods, a car, it's 4 years. A typical contract, not a sale of goods, 6 years. But the one thing I would point out, which certainly very important, what Jamie mentioned, that borrowing statute. So for those of you guys who have contracts or agreements that maybe you're in PA, but the home office is in Ohio and the contract cites to Ohio, you just got to be really careful that if you're over a couple different states in your lending practices, that you get a good handle on that borrowing statute, because what you believe might be the statute very well might not be the statute. So just be careful about that.
Yeah, I'm going to chime in. I can tell you over my 20 years here, you know, there definitely is a trend, and I could be wrong on this, but I'll walk out fairly far on a small branch that would indicate what trend is it. It's getting shorter. I have not seen, I don't think in any state, an increase in the statute of limitations. When I started in Ohio, it was 15 years, then it was 8, now it's 6. They've attempted 3 and 4. There's been some pushback, fortunately, so we've stuck to 6. And by that, I'm talking about general contracts. We've got the retail installment, that's 4. We've got, you know, other ones that would be shorter than 6, but 6 is sort of the primary. And then, yeah, you throw in the borrowing statute. Ohio is one of those that says, yeah, if it's 6, unless it's shorter based on the terms of the contract. And it's not specific, it's not only the terms of the contract. We've got case law that indicates you look to where the payment was made. Was that made in another state? Where is the headquarters for the institution that wrote that? It could, you know, you could have a contract that says the choice of law is Alabama, but they're in Delaware. Well, you got to consider potentially Delaware, and they made a payment in Kentucky. You got to consider Kentucky. So it can be difficult, and it absolutely is difficult. I guess it is difficult, and I think the trend is it's getting shorter. So you know, any other comments on that? All right, great. We can obviously be open to that for our next 20 years, I'm sure, for the same dialogue that we're going to have. How about the next one? Very similar, but instead of looking at when we start a lawsuit, how about how long is a judgment good for? So how do judgments expire in your state? Can you renew them? What are you seeing in your states? Let's start with Mike.
Sure. Finally, a black and white question. Rarely do you have an attorney give you a straight answer. I'm going to give you a straight answer here. New Jersey, 20 years. and then you have the right to revive it for another 20 if you do it before it expires. Clean and easy. Pennsylvania, if you're in our small claims court, 5 years. However, you have the right to move it up to the next court. If you move it up, it's 20 years. And if you're in that court to start with, it's 20 years. So there is the first straight answer without any gray that you've ever gotten from an attorney.
Jamie?
Oh, I'll give you an even straighter answer. So Kentucky it's 15 years from the date of the last execution, which means that as long as you file some sort of execution, garnishment, lien, whatever that is, you can keep that thing good in perpetuity as long as it's once every 15 years. And once it is expired after 15 years, if you haven't done anything for 15 years, it's expired. There is no reviver. Indiana is 10 years, it's presumed satisfied after 10 years, but that is a rebuttable presumption and it's pretty easy to rebut. So essentially, Indiana judgments never really, they never really expire.
How about you, Dan?
Well, I'm going to break this streak. Technically, Michigan adjustments are for 10 years. Yeah. You can renew it for 10 years. It's renewed by a motion. Generally, it's a very administrative type proceeding. However, there's some tolling of that 10 years. In Michigan, we have what's called an installment payment order. And if there's an installment payment order in place, you do not count the time that that installment payment order is in place towards the calculation of the judgment period. There's also some case law out there that indicates that a payment, a voluntary payment on the judgment will extend the life of the judgment. There's also some case law that goes both directions, saying if you receive involuntary money through a garnishment or something along those lines, that extends the period. To be conservative, though, as a firm, we take the position that we seek to renew the judgment prior to the end of the 10 years. If you don't file the motion prior to the end of the 10 years and you don't have a payment or an installment payment order, the judgment cannot be renewed after expiration.
I will get back to a straightforward answer for Ohio. Much like Kentucky, good for as long as you keep the judgment active. So as long as you're doing some sort of execution every 5 years, and that would typically at a minimum be a judgment lien filing, that judgment will be good forever. And so that's the way to keep that going. You do have the opportunity to revive if it goes dormant, but that gets a little bit more complicated. The best and easiest way to do that is to not let it go dormant. So I'm gonna move on to the next question. I think we've got we're in the back half of our time here. So I want to open it up, I guess, a little bit more generally and ask the panelists if they've got any additional early trends that they're seeing in 2023 that they want to raise, or if there are any that they see coming down the pipeline. Who wants to jump first?
I would just.
I'll go.
Okay, Dan.
All right. In Michigan, we've seen courts, if you cannot obtain personal service, you obtain what's called an order for alternate service. And this is a judge-specific order. Generally, it's mailings, it can be posting, can be other things. But what we're seeing now is courts putting requirements to email debtors to known email addresses, and even to post to social media. So it's a little, from my FDCPA side of things, it makes us a little squeamish to complete service, but there is the exception in the FDCPA for orders by courts. We are also seeing some backlogs in filings, not a good thing, but hopefully that'll start being cleaned up as we are seeing more courts go online. We've already had 5 courts go to online filing this year, and hopefully we'll see. We've been paying for it for about 8 years now, and we have a very small minority of courts that are offering e-filing, so hopefully that will improve. And oddly, and I don't know if my colleagues are seeing this, but I have seen a significant rise in ID theft claims. I mean, I used to see one every couple months. It seems like I'm getting one a week now. So.
Very interesting. Mike?
And I would I would just add, I mean, we've talked about a lot of the trends, what Dan is mentioning as well, but to me, it's about 4 letters. CFPB, you just don't know what they'll decide during the course of the year. And that can change where we're at. A recent consent order from a month or so ago is already building conversation related to what are the next steps necessary. So when we talk about going into the next year and the following year, it's all CFPB in my mind. So that's just stay tuned. And the firm, I think we do a pretty good job of running out those updates as they happen. So we're going to continue to do that for you folks. And I can tell you, once the CFPB issues an order or something, you're going to hear from us first, and we'll be able to give you some advice and guidance in that regard.
And one trend I would echo what Dan said. I've never thought really that much about it, but we are experiencing the same thing that sounds like in Michigan is experiencing, which is definitely a rise in ID theft claims, having to go through those. And I think so the trend and the takeaway for the folks here on the webinar is documentation is king. Being able to provide and support, because I'll be honest with you, it's our burden of proof when we go to court to prove these things. When someone raises an ID theft defense, if you don't have a lot of documentation to show the use and receipt of proceeds, things like that, it's going to be very hard to get your judgment. So it really does come down to making sure you are able to document your files, you're able to document what the application process. I will say that something that's clearly happened over the last several years is a lot of these products that are being issued by creditors are, I think the buzzword, what the kids are calling it, fintech, something like that, but using a lot of technology in the lending process. That's great. I love the fact that I can use my phone and get a credit card, right? The problem with that is it opens up to not only potential fraud out there, but also how are you as a creditor going to be able to go into a court of law, the cold, hard, stale court of law, and prove to them and show them how this person applied, how this person benefited, how they received that. We have a lot of things that we talk about, they got statements, all this kind of stuff, but are they getting statements sent through email? Are you capturing IP addresses? If so, how are you able to determine that's that person's IP address? It's a lot easier for us to talk about it here than it is when you get into courts. Also, being able to capture payment information. A lot of people are making their payments online. I don't know the last time that someone sent that I sent a check in to pay for something. Well, that's great and it's very good and very convenient. How are you as a creditor able to determine what the account was and how that's able to translate into court of law, say, no, this person used this is their payment, this is their bank account, et cetera, et cetera. Those are what I see in the future, because we are definitely moving away from what our parents, what we may have used in the past as far as the way that we obtain credit, pay for credit, things like that. It's all online now. And so we've got to be able to not only show that and prove that in a court using rules of evidence and things like that maybe didn't really contemplate that.
So we talked a little bit about looking into the future. Let's talk about the present again, because Dan had just mentioned this as well. And obviously, if any of us that have ourselves, our spouses, our kids, our whoever, social media, right? It's a major thing that's out there and that we're all facing. And Dan mentioned even courts are trying to embrace it for such things as service, which I'm guessing many would have never thought that, but we're here now. Next question we've gotten is, can social media be used for skip tracing and collection purposes, and is there maybe any risk? So maybe one of you jump on this one and let's hear what you have to say on it.
I can say something real quick. The general rule is that the FDCPA and those things still apply for debt collectors when we're in any kind of communication. So if you're using social media in any sort of way to contact your debtors or try to determine information, obtain information about them, you have to keep that in mind. And so the general rule is, if you have public profiles, you absolutely can go on public profiles, look up information. It can be a great source of information, where you go to LinkedIn, Facebook, whatever the case may be. Mike Dougherty is a TikTok influencer for our firm. He's what you consider a TikTok star. And Mike probably, if I go on his Instagram or his TikTok and I see that Mike is sitting out there showing to the world how he just bought a brand new car, I can absolutely use that information however I need. But if that's a private profile, can I create a fake, some sort of fake profile, try to be friends with Mike, which he's going to be friends with me because he's an influencer. He's going to want all of his followers so he can show everybody. And then use that information once I gain access under that false pretense. I think clearly, no, you cannot do that. But what I would the takeaway from this is it's a brand new, it's a brave new world, a brand new world with brand new rules, and everything's changing as we go. So it's a hot topic to stay on top of, and it's just going to develop, I think, more as we move along.
Now, after you just said that, unfortunately, we lost most of our attendees because I think they all rushed to search for Mike Dougherty's TikTok feed. But I hope they're not going to miss this because I'm going to go to Mike on this next one. So next question that we've received involves replevins. And the question was, what should be considered when deciding whether to pursue a replevin action?
Well, I love me the replevins, to be honest with you. And nowadays, I think what we're seeing, I think everyone does as well, because of the value of used car prices, right? That's kind of changed the dynamic. Used car prices are some of the historically high levels. So what do you guys got from your perspective? Well, from your perspective, you got to make the initial decision. Do I just want to send that case over to just have Weltman get possession of the vehicle, or possession and the monetary amount due? So this all ties into your MVN and Reg F. If you're going for the money and possession, we've got to slow it down a little bit because now we have to send that MVN notice. We have to send that initial validation notice. So it's going to slow down your time frame for us to get that suit and try and get that vehicle recovered for you. So what you're seeing is most of the credit unions and creditors are just saying, nope, let's get possession because we want to get it as soon as possible. And the reason is the sooner you get it, you guys are getting great returns on those sales of the used vehicles, which you just weren't getting in the past. And I've seen just a bunch of times where we're not even getting deficiency claims because the amount the vehicle is being sold for actually is paying off the note. So that's kind of the big trend right now is pursuing the replevin for possession only so you can get that possession and you get that vehicle sold and take advantage of these historic high used car rates.
Very good. Thank you, Mike. I'm going to go to the next question, which is going to open us back up to a round robin response. What collection fees and costs, including repossession, remarketing, and legal fees, can be recovered from a consumer? And this is the round robin portion. Does this differ by state? So let's go with Dan.
Yes, I mean, your contract is going to dictate what repossession and remarketing fees you can recover. You definitely can recover your court costs. The collection fees and legal fees in Michigan in a suit, I am limited to $75 attorney fee if I take a judgment prior to trial, and a whopping $150 if we actually have to try it. This is something that definitely changes by state. The courts in Michigan are not big on the collection fees. Most courts in a consumer situation will not allow your collection fees other than the statutory attorney fee.
Jamie?
Very similar, in Kentucky and Indiana, if it's provided for in the contract, you are able to seek those. With, and the exceptions being, talk about collection costs. A lot of people ask that question. What about, can I get my collection costs? Well, in most of these contracts, those collection costs are pretty amorphous. They're not really well defined. And I would tell you that, you're probably not going to get those in a Kentucky court and probably likely not in an Indiana court. You will get attorney's fees if you are, like in Kentucky, you are entitled to attorney's fees if it's provided for in the contract in the event of default. You're depending on the court you're in. Some courts allow a percentage of the principal, which the principal balance is due, which that's about 15%. Other courts require you to actually itemize what you've done and apply a community standard hourly rate to that. So it depends a little bit by court, but you can request them. I think the issue that I see is we can request those, but again, harken back, make sure you have your documentation in a row, your accounting at the ready, and because I can tell you, if you're requesting prejudgment interest, repossession costs, repossession fees, fee for this, late fee for that, most judges, when they come across their desk, are going to want to see not only documentation, but they may want to have a damages hearing to have someone come in and testify as to how those were calculated before they grant them. So again, if you're gonna request them, you can, if it's provided for in your contract. But again, sometimes practicalities, maybe you let those go and just seek principal and like post judgment interest or something like that.
Any difference in your area, Mike?
Well, from what I'm hearing from Dan and Jamie, I guess one of the reasons my TikTok following has been able to grow so good, I've had the time to expand on it, because in PA and New Jersey, if it's in the contract and it's specifically pled, we're good to go to get it for you. So nice and clean, nice and easy. I'm back to posting my TikTok and getting my followers and my influence grow.
Excellent, excellent. I'll jump in on Ohio on this one and just only call out the fact that in a consumer case, in a consumer litigation, we are not entitled to recover collection costs or attorney's fees. Specifically, that answer is a hard no. The others, again, as long as we've got it itemized and we can submit that and the contract allows for it, yes. But a very hard no on the attorney's fees and collection costs in Ohio. I want to move to the final question we have on a slide here as we're wrapping up. We had someone that asked if a consumer is on a fixed income, can collection activity take place? And I thought maybe perhaps we look at one, the legal aspect of this, but two, what are the practical and strategic side of this?
I'll take this one. I mean, yeah, can collection activity take place? Yes, just because they're on a fixed income does not mean you cannot attempt to collect against them. Really, the question becomes, is it the best use of your time? If you have somebody who's receiving strictly SSI or SSDI, living in an apartment, owns no personal property or no car or what have you, I think you're wasting your time pursuing that. You could open yourself up to a harassment type claim. Now in Michigan, we do have something called a tax garnishment, where I can actually intercept an individual's state tax refund through a garnishment. So if same situation, except they own real estate, they're automatically going to receive a tax refund, and I can take the judgment, I can issue the tax garnishment as well as a judgment lien, and every year receive, depending on how it's set up, $300 to $900 to put towards your judgment. So in that case, it makes a lot of sense. So that would be one factor that I would look at, and how hard I want to collect, or what efforts I want to put in to collect against is, what is their income? Is it fixed? Do they have other income? How much is it coming in? But that's only one aspect that we would consider. We would look to real property ownership and other factors as well.
Thank you, Dan. So I'm going to start wrapping this up. I know we've received a number of questions throughout this session, as well as you were registering. And we're going to do one of two things, and maybe both. One, we're going to continue to take a look at those questions. We will be reaching out to some of you individually with some answers to some of those, just because it's the right thing to do. And then second, you may also have given us a round two of hot topics that perhaps will bring the gang back together and put something else on for you. So I wanted to at least call that out. And then ultimately, I'm going to close by saying thank you for attending today's Weltman's webinar. We hope you found this presentation informative. As a reminder, a short survey will pop up on your screen when the webinar ends. Please share your feedback and let us know what future webinar topics you would like to see. I would also like to share that we have a complimentary library of over 40 webinars that you and your team can view on demand. Our collection offers information on a variety of topics, such as collateral recovery, real estate, and bankruptcy, to name a few. We'll send you a link to the library in our follow-up email as well. Thank you again for attending. Thank you to all the panelists today, and have a great day.
Thank you.
Thank you.